Hi everyone, I'm America Josh and welcome to our monthly webinar and podcast series with experts from all sorts of different spaces that can make your lives just a little bit easier. If you're not familiar with what I do, we've got a community of over 75,000 Australians living in the US or wanting to move to the US, and we're here to make your lives, their lives just a little bit easier and make the transition to the US and life in the US a little bit more successful so that you can stay longer and enjoy every part of the United States. Tonight I'm joined by Shannon McNulty from the Village Law Firm, and we're going to talk about estate planning and wills. Shannon is an estate planning attorney in New York, and she specializes in international families. So Shannon, you're the perfect person to have on tonight for us and talk through some of the issues that you've seen popping up. You've got Australian clients, which I'm sure we'll talk about in a second, that you've actually gone through this directly with them before. So it's going to be the perfect opportunity to ask you some questions. We've had all sorts of questions submitted tonight from all of the registrants that are joining us tonight. So thank you everyone for your questions. It means that we can tailor these webinars and podcasts really to answer the questions that you actually have. Before we do start, I want to quickly share a little disclaimer. There we go. The information in this presentation does not constitute legal advice. The information presented in this presentation is for educational and informational purposes only and is of a general nature. It does not take into account your individual objectives, situation, or needs. It should not be used, relied upon, or treated as a substitute for specific professional advice. Shannon, the Village Law Firm, Josh, and America Josh recommend that you obtain professional advice before making any decision in relation to your particular requirements or circumstances. Always love starting with a good disclaimer to get us off. I also want to note that we are recording this, so if you hear something that you're really interested by and you want to hear it again, you will see. We've just had someone else join us. We've got, looks like I'm going to hide that. There we go. It is being recorded. Everyone is muted, but you can use the Q&A and the comments functionality. So if you do want to leave a question, I will try to get to all of the questions as we go. As I said, we have curated all of the topics that we're going to talk about tonight based around what was submitted to us in registration. So I'll try and fold in some of the questions for you, Shannon, as we go along, and we'll see how we go. But I want to start by, do you want to introduce yourself, the law firm that you've got going, and like a little bit of background about the people that you typically work with?
Sure. We focus solely on trusts and estates and estate administration, or boutique firm in New York City, and we have a lot of people who are cross-border clients. Almost by nature of practicing in New York City, you're going to have a lot of those clients, but there aren't a whole lot of firms that cater to that population.
Really specialize in this space.
Yeah, especially if you're not looking for the mega big firms. So you might find really large firms, but you're paying thousands of dollars an hour, and it's just not really viable for most people.
So is your, like, the way that you work is really, like, it's interactive, right? That's you sort of actually get to sit down with people and talk through things in a slightly, I guess, longer form than a lot of lawyers would engage with their clients. You get to sort of really hear a story about them.
Yeah, we really focus on holistic planning. So not just, it's my very strong belief that estate planning should not just be a set of documents. It should be an overall plan that incorporates what assets you have, who your people are. If you just have a couple of documents, maybe no one knows where they are, maybe they're lost, or they don't reference all of your assets, so your will doesn't actually say what all of your assets are. So you wouldn't believe how many times we have people who end up going on a scavenger hunt trying to find like literally calling every bank in New York City, seeing if this person had an account there. So those are the kinds of things that we see fall through the cracks a lot. So we want to make sure that doesn't happen.
No, and I know when I was making some of the promotional and talking about to people what we're going to do tonight, it's this idea of not just sticking your head in the sand, not saying like, I know I've got it somewhere, because turns out having it somewhere is not actually worth anything if you don't know where it is and how it actually fits together, right?
Yes, I talked to a man the other day who had his will somewhere in his storage unit.
Oh, brutal. I think there's a lot of people nodding along right now, because storage units are one of the things that I tell everyone when they move. don't take a storage unit. You're never going to look in that storage unit. You don't know where anything is. You don't know what's in there. So that applies to wills as well. It's the perfect segue. I guess there's no point sort of darting around it. The big question that we got a lot of was around, do you need separate wills? We'll talk about Australians living in the US. It applies, I'm sure a lot of this applies more broadly to wherever you've come from. But for Australians living in the US, if you've got assets in both of those countries, or if you don't, do you need wills in both of those countries?
So I'm going to give a very lawyerly answer, which is it depends.
Yeah. I was going to make a little pop-up that just popped with the it depends.
Absolutely depends. It depends on what assets you have. It depends
Okay.
on, do you have minor children? It depends on whether you have, what the value of those assets are. Sometimes I have clients who just have like a small account abroad and they just use it when they're there. It's like $5,000 or $10,000. And I'm like, you're going to pay a couple $1,000s to get a will there, it's probably not worth it. So it really does depend on a lot of different circumstances. Having one will that you expect to cover like all of your assets, and you have property and you have real assets in many different places, is probably not a good idea, because the requirements, say in Australia, are going to be different than, not even in New York, they could be different from Oklahoma or something like that. So even among the states, they can be different. And so you can just imagine that having a will outside of the US, the requirements can be very different. It also just usually takes a lot longer if you only have one will, because you have to wait for your primary jurisdiction to be finished with their proceeding before starting the secondary jurisdiction if you only have one.
Okay, do you want to talk a little bit more about that? So if you've got, I think there's probably going to be a few scenarios here, and again, this is general, so we're going to try and sort of keep it lofty, but if you've got a will in Australia and you live in the United States, so you've kind of said, like, I've got a will. You've sort of said that to yourself. I'm sure everyone's seen the commercials in Australia that was like, you need a will. They've done that. If you passed away in the US, what does, like putting aside in the will process, what is the general process that then happens for someone if they die in the US?
So the first thing that you want to look at is, where was that person domiciled?
Okay.
Domicile is kind of legal jargon for what was your permanent home and where did you intend to stay. So we would look at what kind of visa did they have, what plans did they have, were they applying for a green card, were they applying for citizenship, had they moved back to Australia. There's a lot of things that go into that. But you're going to look at like what is the domicile of that person, and then that's going to be your primary jurisdiction. So that's basically where you're going to start, and then everything else is going to be called what we call ancillary.
Okay, so it's not necessarily, does the recency, like, does the newer one negate the older one, or for this person, if they only had one in Australia, that would be like US law if they're living in the US, but you've just said that if they were temporarily here and it was only a visit for a certain amount of time, that might mean that it reflects back to Australia and the US doesn't really play as much of a part potentially.
Yeah, basically you're going to start with the domiciliary jurisdiction, which in this case, if they were here temporarily, would be Australia. So that's going to be the primary proceeding. And so you're going to start with, was there a will there? Was there a valid will there? Did they do a will in New York, but that's not valid in Australia? So you would start with that proceeding, and then you would start coordinating with the attorneys in the other countries to see, was there a will? Did the Australian will cover the US assets? Did it not? Were the assets in the US, were they estate assets, meaning that they would go through a will? Maybe they had a beneficiary designation on them, so they wouldn't actually go through the will. So it becomes very complicated. I hate to tell people that I can't really answer these questions. Sometimes it's really hard to answer these questions
for sure
simply. But if you do pass away, I think the really important thing is there's not one answer for everyone.
Yes. Yep.
And the important thing is to get the right advice ahead of time and make sure that it's done thoughtfully, whatever is the best arrangement for your situation.
Okay. So in most cases, and again, I know we're speaking generally, but if you've got assets in both countries and you've relocated and you've got a life here and you've got potentially a house, I think a normal scenario for a lot of people would be an investment of some situation in Australia. You're living here. Do most people end up, and I know it very much depends, but do a lot of people end up with wills in both countries? Is that a practice that can happen and is sort of a valid process for some?
Yes. And you just want to make sure in that situation, what we do is carve out the other country. So we'll have kind of the primary the will for the primary jurisdiction, we'll carve out the assets in the US. And then the assets and the will for the US will do the same in terms of it will just apply to the US assets.
Got it. Okay, so the sort of best practice again for this particular scenario is actually that you rewrite both so that they both have an understanding of each other. So it's not that one existed and then you say, we're aware of the other one, but this one only applies to a little bit. It really does work in sort of the gold standard, I guess, would be that it's one that are both written at the same time that say this is written in Australia by an Australian wills and estates planner. This is written by a US attorney, and they're both sort of interacting with each other and you're communicating. Is that something that you do? You communicate with attorneys in Australia?
All the time.
Yeah.
All the time, yes. So ideally, gold standard is you're doing it at the same time, but it doesn't have to be. It could be one later. Maybe you did your will in Australia originally, and then we can take a look at that and see is it going to have any impact here. And also, what we do like to consult with an Australian attorney who drafted it, just to check in with them, make sure that there's nothing that we're missing.
Yep. Okay. So then, if somebody does have multiple wills, in terms of like logistical storage and actually having copies, do people who retains copies? What's the best practice for if that's your situation?
So wills is the one document that is still very much analog, and digital copies, any copies, are not accepted by a court, at least at this time. So having that original signed document is really important. So you want to have it either, you can maintain it, but you want to make sure somebody knows where it is. So you can put it in like a fireproof bag or something like that, or a safe in your apartment. I'm
already feeling like looking around like, where did I put mine? It's not in a fireproof bag yet, but it will be after this webinar, I promise.
Yeah. I mean, some people just put it in their filing cabinet, but just make sure that somebody knows where it is. We also provide that as a service to our clients where we store those documents for them and just meet with them every year. And also just making sure, like I said, all of those other things, like you opened a new account, is that going to fit into your estate plan? Kind of like so that it's a living plan, and then we can serve kind of as like a resource where somebody can just call us, like if there was an issue, there was a death, God forbid, or something like that, then they can call us and then we would be authorized to release those documents.
Got it. And are there particular like styles of life event that lead to the evolution of a will that like really need to be? So I'm thinking, children are probably going to be the really big one. Are there other particular ones that really come up that people need to think of as like a big stage in their life that they should come and talk to you again?
I'm actually going to say anytime you leave, like you move countries,
you
should probably get some advice. Because it's going to affect taxes, it's going to affect if you got into an accident, you're in the hospital, who's making decisions for you, who can access your assets to pay your bills, those kinds of things. So once you cross borders, like everything really changes. So I would say that's probably something that really people should think about, especially if they have kids, it becomes more important.
Okay, and you mentioned before that, like even state by state, and I'm sure a lot of people are nodding their heads because when you move from Australia, especially to the States, you're moving to one of 50 countries not 50 states, because sort of I think most people in Australia think of it as, an Australian will would of course apply to other states, and there might be nuances, but it does. Here, like, you're based in New York, so do you do New York wills, and then you'd speak with a wills and estates attorney who might do one in another state, and you'd work with them to fit into that package? Is that how that works?
Generally, will is going to be valid in all of the states.
Okay, right.
Depending on in New York, we have one of the strongest requirements in terms of we need 2 witnesses and a notary. Not all states require that. Sometimes you may have a valid will somewhere else, but if it comes into New York, it could be valid, but it's going to cause other issues. So in terms of having the will done here in New York, generally any other state it's going to be valid in. But there still could be other issues. So for example, if you, in New York, you have to have as your executor, a sole executor can only be somebody who is a US citizen or a New York resident. A person outside of the US cannot be the sole executor. And if they are not a citizen, they have to be a resident of New York. So that is something where, if you moved and they had the same rule in another state, then that could cause an issue. So that's probably one of the circumstances, one of the few circumstances, but it does come into account more often when we're dealing with these intricacies of cross-border issues.
Yeah, okay. And obviously your specialty is in this sort of international element. Is the unique part the fact that you've just got lots of experience and you know sort of the things to look out for? You're asking more questions. What is the unique value, I guess, that you can provide someone? Because I guess there's lots of offerings, and it's just sort of interesting to hear what are the probing things that you sort of get to that most people don't.
I mean, even that first question of where are you domiciled? Where's going to be primary jurisdiction? Making sure you have a backup for the guardianship, what that process is, if that had to come into being. That if you have often, for clients who are born outside of the US, their family is outside of the US. That's I would say that's one of the main challenges more than anything, is who are your people? Because the people are not going to be that you generally would rely on in those things for those purposes are not there. And so trying to help clients navigate those issues of how can we think creatively about this? What people can we put in? It's okay if they are not a US person, but where do we want to reinforce that with, we need people on the ground here, and where are we going to find those people?
Yep. Okay. And I realize this is getting more and more nuanced, but if you've got more locations, it doesn't really matter. So if you've got a third country, for example, I know that we had one question come in that said that they were, or a couple of questions actually, that said that they had locations based in the UK, Australia, and the US. It just again becomes just a bigger tapestry, but the same nuts and bolts. It's just basically you're weaving together how they all interact.
Exactly, yeah. So we're again looking for where's the primary jurisdiction, then the other two would be ancillary, and often we're doing 3 wills in 3 different countries. It can get a lot, very expensive, a lot of lawyers involved. So I do encourage people, if you have a lot of accounts in different countries, just consolidate them if you can, because it really creates a lot of complication. And if you think it's expensive on the front end, the people who we deal with who these things haven't been taken care of, it's far messier and far costlier.
Yeah, and I know I can sound like a broken record, but the putting your head in the sand turns out not a good strategy. And we've had the last webinar was on financial planning and then tax planning and all of this. The best thing you can do is, I guess, air it. So if someone's sitting here going shit, I've got some things, is that sort of part of the first chat that you have, is sort of just airing here's my situation, and you kind of give a quick top line situation, and then your real work is actually setting up and doing all that liaising and actually writing the wills?
Yeah, so usually how we work is that we'll do a consultation. We'll have people fill out questionnaire before that. First, we'll talk to them. Somebody will talk to them and make sure that we are the right person for them.
Sure. Yep.
If they're, again, in California, we might not be the right attorney for them. But then we'll have a consultation. We'll have them fill out a questionnaire about their situation beforehand. So then we basically just get a lot of information about their situation, their family, their finances, all of those things. And then I'll give them kind of like a crash course on estate planning, especially the issues that can come up when we have cross-border ties. And then we talk about kind of like what structure makes sense to address all of those things for them.
Okay, cool. I'll make sure to share. You do a 15-minute onboard free consultation. So I'll make sure that I share that. Everyone will get an email at the end of this with your recordings, which will include a link to Shannon's 15-minute consultation. You mentioned guardianship before, and I think that's a good second stop. Can you explain what guardianship, what it is as a concept, and who would be looking into guardianship, and then effectively, what's the top line about how that works from an international perspective as well?
So minor children under the age of 18 have to, by law, have a guardian. They cannot legally make decisions for themselves, so they have to have somebody who's responsible for them. When the parents are alive and there, it's naturally the parents are the natural guardians. If something happened to the parents, then somebody has to be appointed for that child. And this is why it's really important to kind of have all of these documents prepared and the preparations with respect to like who is going to take custody of that child. A big misconception that we hear is that a lot of people think, my sister will just come. She'll just take a flight over,
fix it,
get my child, go back, and it'll be fine. And it's just not that easy at all. So there is no legal right for your family member to take a child outside of the country, because they are going to be stopped at the airport and say, before they get on the flight, like, you're not a parent, you're not a legal guardian, you can't go anywhere with this kid. And if there is not a good plan in place, the child could end up in like foster care, basically. That's kind of like worst case scenario.
Sure, but terrifying, yeah.
Terrifying, and especially I think there's just a higher risk of that when family is not around, because there's nobody to just like barge in and be like, okay, like whatever has to be done, I'm the grandmother or the aunt or whatever. So that is like just a nightmare. So we want to make sure, like, at all costs we avoid that.
Okay, you just mentioned worst case scenario, and I just wanted to quickly touch back on wills, because if you don't have a will, you're this scenario where you've got Australian assets, some US assets, you live in the US, you're on a temporary visa, so you're on an E3, and you die, you don't have a will. What actually happens? And I guess the reason I thought of it is because you said for guardianship, it doesn't just automatically default that like a family member can take that over. Is that kind of a similar vibe, that like it comes down to court proceedings and things? What actually happens?
So Child Protective Services will come and take your child, and then they will be assigned a family until somebody from the family petitions for, or somebody petitions and is appointed as the guardian. That's kind of what happens in terms of your children. Children,
yep. And then in terms of assets, like in terms of stuff, like and the things that you have, is it a similar process?
So if there is no will, this is where it really does depend on the jurisdiction. Definitely every country is different, even every state is a little bit different. So in New York, for example, if you are married and you have kids and you pass away, a lot of people think that everything goes to your spouse. It doesn't. It's 50% goes to your spouse and 50% goes to your children, even if they're 5. And if your kids are 5, then they need a court guardianship over the assets, meaning that the court supervises those assets until the children turn 18.
Wow. Okay.
That can even be the case where the other parent is surviving, and now they have to
And
ask
it's
the
happy
court.
families and everything's fine, but it still has to become.
They have to ask the court for permission to use the money for their own children, and so it's not
Boy, yeah.
something. Yeah.
I'm definitely checking my will right after this. Okay, so, and sorry, I know that was a little sojourn back to wills, but so then back to guardianship. If I know a lot of people will be watching and saying, like, I don't really have anybody here. Like, I've got friends and I've got but I don't have, my people. My people are back in Australia. I've got family in Australia who I would be very confident. It's always been that my sister would take them. And what is there a sort of a way that you can design it that can be like I've got a short-term plan and a long-term plan? Is that like something that you can structure for children that you might have to sort of like, it can be a full story for the court to sort of say, like, here's what I want to happen over the course of the next 3 months kind of thing? Are there accommodations for international people?
So that's exactly what we do. And when we have a foreign guardian as the preference, that we designate them as the first choice of guardian, but then we would have somebody as the alternate in the US as the backup, basically is temporary until the foreign guardian can be appointed.
Got it.
And
Okay.
if you don't have your people here, like, you might have to think outside the box a little bit. Like, your Australian community, do you have people in your community who may be in the same situation, and maybe they need somebody to serve as the backup? And honestly, this is like such the worst case scenario, right?
Absolutely. Yep.
That like most people will take your kids.
Sure.
I
Yeah.
don't know
Yep.
anybody's
Deep
kids.
down. Yeah.
Maybe
Somebody's.
a particularly terrible kid.
My kids are lovely. Everyone would take them, I promise. Yeah.
But even just friends that you have in the community, you can explain your situation and say, this is like very unlikely scenario, but we really need somebody who we can trust. Is this something that we can ask of you? We know it's a lot.
And that would be it can be time limited, and it can be very much that you are the backup. This isn't something that, like, you can structure it in a way that can be very practical, I guess would be the way to put it.
Yeah, so it can take a long time. So
Okay,
it can
yep.
be basically the way that is structured is that as soon as, like, that person, say the US friend or whoever it is, they would be the guardian until the petition for the foreign guardian is approved.
Okay, yep.
But it can take much longer than 3 months.
Okay, so that's a good point. So for the will process, if you've got a will and you died, how long is the process generally? Like, on average, how long does it sort of take from, like, yay to nay, to like process it and sort of have everything done? Is that you just sort of said 3 months for children, or 3+ months for guardianship issues and for assignment of that kind of thing? For a will process, what do people generally expect?
So for guardian, I will say it's more like 6 months to a year, probably.
Okay, wow.
In terms of the will, again, this is one of the things that vary so much because as their property, there's a lot of variations there. But I would say that's probably going to take at a minimum 6 months.
Okay. Yep. And that's having, like, so 6 months would still be like, you've got someone in the US, you've assigned it properly, you've done all the allocations, you've got interacting wills in both countries. Like, that's, if everything is sort of perfect, it's still going to take some months to get really out of the wash.
Yeah, and I would say that's like you have one beneficiary, you don't have, like, even if you just have New York as it, right?
Yeah, okay.
So you have like another country we're looking at well over a year.
Okay. I don't know what I would have thought. Like, I guess that's a longer process in my head. It's like, you've signed all the documents, you kind of assume that it would be a tick, 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 but I guess, yeah, it does take time. Is that, sorry, I know I'm getting into the weeds here, but, like, is that people going to court? Do the people that you assign have to go to court and petition? Is that something that you do as a lawyer on their behalf? How does that sort of look here?
So it's usually just done all by paper.
Okay.
So usually people don't have to come to the US. We can do it virtually, but there is a lot of time of getting the right documents. You have to have something called like an apostille document. It's like a special certification from another country for the will, the death certificate, things like that. You may have to wait for the court in one country to finish its proceedings and to start in the other country. So there's just a lot going on, and it doesn't always, it's hard, one, to get the documentation, and then two, we have to wait for the court, and we don't have control over that. So sometimes it can be quick, sometimes more than this time frame depends a lot as well on what state you're in, even what county you're in. Some counties can be within New York State can be faster than other counties.
Okay, but it is I feel like just setting the bar at, it's going to be a 6-month process at the very least. I feel like that's an important thing to go away with. If nothing else, like, you need a will, you need to plan for your kids, especially if you've got them, and then you need to know that it's going to take a while for things to resolve. I know the next, like, sort of the segue that I've got, and I think,
if I can just,
please,
I'll
hide my cool.
Yep. So because of that long time frame, we generally recommend that a lot of our clients do something called a revocable living trust.
Okay.
And that's a lot like a will, but it avoids the court. So it's just a lot faster and a lot simpler. So especially when we have people abroad, and you want to make sure, say your friend down the hall, they do have to watch your kids. You don't want them, they don't have the money or the money to like
sure.
watch their kids, right? So you want some plan to make sure there are assets available quickly to cover at least those expenses.
Sorry, and that was a revocable living trust?
Yes.
And does that exist in addition to your will, or is that in replacement of a will, or is that part of the ensemble of things that you will create when doing it all properly?
Usually in addition to a will.
Okay.
Ideally, everything goes through your trust and nothing goes through your will, so you don't have to wait for the court at all. But sometimes there's things that are left out of a trust, or we can't put into the trust for some reason, so those things will go into your will, and the will, we call it a pour over will. The will pours over into your trust. So the trust will be the main document that says who gets everything.
And for that kind of thing, because obviously that sounds like assets and like it's all sorts of things interacting in your day-to-day work, and if somebody approaches you and says, like, I have this going on, do they then like bring in their financial planners or their accountants? Like, is that sort of, do you all sit at a big table and sort of talk it through? Is that, or is it something that is this sort of a siloed thing that you do?
So you have to remember, like, the type of planning that we're talking about is only if you're dead.
Got it. Sure. Okay. Yep.
So generally that financial, like, it's not as much. Sometimes we'll...
It's less planning, more,
advise, like, do we have enough life insurance, things like that.
Yep.
If we get into more complex tax planning and things like that, irrevocable trust, that's where you would need your,
Got it. Okay.
People. But in terms of, for most people, you don't need to have, like, this whole big conference to...
Got it, because it's revocable, right? Of course, yeah. So you're not putting things away while you're alive. Okay. So this is something that they'd approach you and say, like, here's my situation. So in a lot of these cases, they'd set up both their wills to have that just in place, because there's some things that can't make it into the revocable trust agreement. The revocable. I've forgotten it already. Revocable living trust. Cool. There's some that you ideally put a lot into that so that it can quickly distribute and go to whoever you want and make sure it happens. There'll be some residual elements that will stay that have to be done by the wills. That will take months. To flesh that out, because we're talking about guardianship, do kids come into any of that, or that's all part of the guardianship set up in the will, and that has to go through that process? There's no sort of quicker way to do that?
There's no living trust for guardianship.
People, yep. Good. Probably a good thing. I'm sure there's a... So we're not putting the kids in a trust, but I think there's a few people, like, I'm going to talk now about, like, estate tax and inheritance and like the elements that are playing part when it comes to finances. I know some people are going to sort of say, like, I'm not wealthy enough to have estate planning. Like, I feel like the term for some sort of really sounds like something that I would only if I have estates, and I don't have an estate. I've just got, a few assets and things. What does it look like as a non-citizen when it comes to estate tax planning and inheritance and that kind of thing? What does it look like as a non-citizen that's different, I guess, from a citizen?
So I'll say there's, for estate tax purposes or inheritance tax purposes, there are kind of three main categories of people. One, you have U.S. citizens. That's kind of at the top of the list that are most ties to the U.S. Then you have green card holders.
Yep, so permanent residents.
Permanently reside here.
Yep.
And then you have people who are here on temporary visas.
Yep.
Okay.
So a lot of the people that are watching are probably temporary or green card, but mostly temporary, I would assume.
So for the most part, the green card holders and the US citizens have very similar estate tax rules.
Okay.
They have a very large exemption. Right now, it's about $15 million per person. So if you have an estate less than that, then you don't have to worry about any taxes. So that's like kind of the most generous.
That's the first blanket rule. Yep.
Yeah. So if you are a US citizen, if you're a green card holder, then you fall into that generous bucket. These are rules of thumb. Just to kind of like caveat.
Yeah. Yep. Lots of caveats, yes, but yeah.
If you are not a US citizen, not a permanent resident, then you are subject to a different set of tax rules. And the exemption for non-resident, non-citizens is only $60,000.
Which is nothing close to 15 million.
Nothing close to $15
okay.
Yeah.
So that is, if you are inheriting, this is money coming in to you. This is like what you are allowed. No, so this is if you're giving it out.
This is money if you die. If I have $15 million, I'm a US citizen, I can leave it to whoever I want and there's no tax.
It just goes away. Got it.
Yeah.
Yep. Okay.
If I pass away and I have US assets, and I'm not a US citizen, not a US permanent resident, then I only have an exemption on those assets of $60,000.
Got it. Okay. And that's US assets.
US assets, exactly. So if you're a citizen or a green card holder in that first bucket, that 15 million applies to all of your assets worldwide. So it doesn't matter if they're
so it's just like tax, similar kind of thing to tax, where all tax is included
exactly,
for a citizen or resident.
Like the income tax for a US, yes. And then for the temporary residents, then it's that small exemption, but it's only on US based assets.
Okay. And this applies to like giving money to spouses, right? So this is where if you've got one that's a citizen, one that's not a citizen, or one that's citizen or permanent resident, and one that is not a citizen or permanent resident, this can still apply. So they can still be, I guess that's a likely trap.
So there is a little bit higher of that exemption. Well, it's for gift taxes of about $160,000 per year for gift taxes. And then, but for estate taxes, no. So anything going to your spouse, unless your spouse is a US citizen, is going to be subject to that very big tax.
Okay. Woof. Could get very pricey very quickly, I imagine. So if you're changing status, so please, yeah, go.
Sorry, just because there's another important, very, very important caveat for your audience, and that is that tax can be alleviated by treaty. And Australia, there are not that many countries that we have gift and estate tax treaties with, but Australia is one of them. And it's a very generous treaty. So you get closer to somewhere near that, like 15 million. It's not great because you still have to file a tax return and claim a treaty benefit and things like that, but it's a whole lot better than paying 40% tax on everything.
Above 60,000. Okay, so there is a way to do it, but you need to, I guess this is again when it comes into the planning. So having that whole process in place ready so you know it's going to come so that you, and this would, for the revocable living trust that we talked about, this all still applies. Like this is all part of if your money goes to a spouse, this still triggers.
Yes, so the revocable living trust is not going to have
Doesn't
any
alleviate any of this.
impact on your taxes.
Got it. If you have arrived here and you're on a non-resident visa, so you're on an E3 visa for a lot of the Australians, they would you, I guess, to go back to our sort of to frame this all out, it is advised that you would set up, even though you're a non-resident, you'd still set up sort of the two wills in each country if you're going to be here, and you'd have them interacting and making sure that they're doing the right thing. Then when you become a green card holder, for example, if some people would be going through that pathway where they'd go E3, then green card, and then a citizen, at each of those turns, I take it you would then re-sit down with you. That's another one of those life events where you'd say, like, okay, let's reassess. Let's make sure we've got a plan for what changes.
I would say when you go from not planning to stay here permanently to planning to stay here permanently, that's when that shift takes place. Even if you don't have your green card yet, if you're planning, if you applied for it, if you're planning on applying for it,
okay,
it is that like domicile issue.
It's a real soft, fuzzy version of
It is subjective. So if you're planning to stay here, then, but that's where we also want to like document that so that we have some ground to stand on. But then once you're planning to stay here, that's when you're going to want, then you have like a long-term plan here.
Yeah, okay. Yeah, so, and it's not, because I know there's going to be some people sitting there saying like, it's a E3 visa, it's a 2-year visa, it's a non-resident visa, I can't stay here permanently. So, that's fine, but if you're renewing it and even in the deepest parts of your mind, you're sort of saying like, I might stay long term. Like really it's about just verbalizing that to you, for example, and saying like, here's my kind of want. I should express that so that you can say, well, you haven't triggered anything yet, but if you did this.
Yeah. Like, did you overstay your visa? That's not a good thing generally, especially not in this environment. But then we might say, well, they're planning to stay because they just stayed and violated their visa. So it could be helpful in this situation. But those are kind of like, it is technically in your mind, but we need evidence of like what it was. Like you were preparing paperwork to apply or something like that. That you had some evidence that you were planning to stay.
Yeah, got it. I know some people would have co-ops and have property here in the States. Do you want to explain just like, because I know co-ops are a very sort of particular like mechanism. Is there a particular thing that people need to know if they're involved in a co-op and they're in New York about estate planning?
So co-ops is very similar to just regular real estate. It's just more complicated.
Sure.
So it's really hard to put those into a revocable trust or any kind of trust for that matter, especially if there's a mortgage on one. So it does make things a little bit more complicated, but not. It's more administratively than legally that it's an issue.
Okay. We did have one question around the living trust that has just come in. They've asked, is it one living trust or one per country? So is a living trust something that's just in the US, the revocable living trust, or is that something that you'd set up in both countries? Or
yeah, that's a great question. Generally, we limit the trust assets to your US assets. And then sometimes people will set them up in Canada or other places, but we generally, it could trigger adverse tax consequences by putting other assets into your US trust. So we want to be really careful about doing that. And that's where I would never do that unless we had definitely advice from the council and
got it. So again, there's a lot of nuance about how that all shakes out. I wonder also, because I know we're going to have people with older parents and they're sort of doing their planning and they may receive an inheritance. Is that something that you like that they can sort of bring to you and say, like, do my family members need to structure particular things, or like obviously they would have to come into the situation as well. But is that sort of something that part of the holistic planning that you can assist with as well?
Yes. So generally, if your parents are likely in your for our audience
Home country,
here,
yep.
they're going to be in Australia. So they need to, they're again kind of going back to the domicile concept, their primary jurisdiction is in Australia, so their primary planning is going to be there. We can assist in, say, kind of how is it best for you to receive that inheritance? Do we want to put some kind of asset protection on there? Do we want to protect it from estate taxes here, either at the federal level, or we have our own estate taxes in New York? But for the most part, if it's not a substantial amount of money, I would say I don't think it's that important to really do that.
To overly plan
like,
it. Yeah.
Cross-border planning.
Yeah. Okay. So it'd be something that you discuss, but it's not something that people, as a general rule of thumb, again, this doesn't apply to every single person, but as a general rule of thumb, it's not something you sort of need to be like constantly aware of and worry about. Because I know it's a topic that, like in my family, it's like I have no concept, and it's something that like I would definitely raise just because it's a misunderstanding of how taxes work and how inheritance works, and you're kind of always worried that you lose a huge percentage because you just didn't think about it. So it's something you can raise, but in general, it just doesn't come up as a big enough issue to worry about.
Yeah, because for most people, they're going to get that inheritance and liquidate it, and then it's going to come over here to the US and to their accounts, and it's not going to change their plan at all. If you inherit a house and you decide to keep that house over there, or if your parents had a business and you're going to be inheriting a business, that's something different. But for most simple matters, it's not going to cause any complications. I would say you do have to file, there's no tax on receiving an inheritance from a foreign person, but there is a reporting requirement, and you want to make sure that you report any bequests or gifts you receive in excess of, I think it's $100,000 in 1 year.
Yeah, and we've got some really good webinars on tax and estate planning, not estate planning, on financial planning that we've done in the last few months, and it's worth watching because there are a bunch of triggers, and as you just said, they're not necessarily tax incurring events, and therefore you don't have to worry about it, but you do have to tell someone, because if you don't tell someone, you will get a fine, and the fine will be substantial in many cases if you don't file those documents. And I think this goes to say, again, like I'll do the selling part of sort of speaking to someone like yourself, or speaking to a financial planner or a tax accountant that has a global knowledge. It's a different set of nuance and a different set of questions that you get asked, because most accountants, most tax planners, most wealth and estate planners don't know. Is it that they don't know to ask? Is that basically they've done it this particular way? Like there might be an estate planner in New York, they know what to look for, they tick off all the boxes, and they just don't look further afield than that. Is that right to say?
Yeah, I would say a lot of times people they won't even work with you.
Right, it's just too complicated. Yeah.
Yeah. But then you can just also have, you're not experienced. If they're not experienced enough, they may miss something.
Yeah. Okay. On that, someone's asked around, like, do you have connections to people in other states that you'd recommend? Like, because we've got viewers that are coming in from outside of New York. What's the best way to look for someone in your profession? Is it reaching out to you and then starting the journey that way, or is there a sort of mechanism that people should look out for that is a trusted person in this space for an international?
Yeah, so we advise in New York, New Jersey, Pennsylvania. I would like to say we have a whole lot of people who I can refer to, but we do have a community of people that, like in our bar association, we reach out and get a recommendation. Usually somebody has some recommendation. It really depends on your state as well. Like if you're in Florida or California, for sure we'll be able to come up with somebody. If you're in Iowa, like you may have to have somebody like me, but co-counsel with the local attorney there.
Got it. So you can sort of be there to add the international flavor, I guess you'd say, to understanding like, oh, we have this nuance in New York. It's probably the same, at least to provoke the questions, and then the local person can sort of tease that out.
Exactly.
Got it. We've got one question that came in that was around, we talked about like you don't have to worry unless it's a substantial amount of money. Is there sort of a a number, and again, this is a very individual question, I understand, like it's not just going to be a blanket rule, but like, is there a certain value of inheritance that might be coming to you that you need to sort of be like, hey, if it's this much, you really should plan whether it's coming in or out?
I would say like over $1 million.
Yep. Okay.
Probably. You want to probably have a conversation about that.
Yep. Okay. So that kind of money, if it's obviously there's always going to be nuances, so it's always worth expressing and having the conversation. But if there's numbers that are being thrown around like that, it's worth having a plan and actually talking it through, just to have a structure about the whole thing.
Just to make sure you're making an informed decision.
Yep. Okay. I want to, in our last few minutes, I want to go through a couple of myths because I know that we see some of the questions that came in. We saw a few things recurring. So I'm going to pop up a few. So myth number 1, my Australian will covers everything. And a lot of this you've covered already, but I just want you to sort of hash into this. So number 1, my Australian will covers everything. Can you debunk it?
Yeah. So well, I will say it can cover everything, but it can create a whole lot of complications. At the time, you're going to have a lot of probates, and it's going to be a lot messier than if you had 2 wills. So, and you may have things in your Australian will that's going to cause issues and maybe tax issues or something here that you didn't realize.
So that can come down to the structuring or the wording or just like the overall, like all of those little nuances. If you haven't said like a particular string of words, then it has a different cause and effect over here. Yeah, got it. Number 2, I'm not wealthy enough for state tax to apply to me.
That's probably most people.
Yeah.
So you may not, I would say a lot of our clients, they don't have an estate tax, but that doesn't mean they don't need an estate plan. If you have kids, I'd be much more worried about my kids ending up in foster care than an estate tax.
Well, you've terrified me completely. I'm going straight. Yeah.
Yeah, taxes are like the easy part,
Yeah.
So I would say planning is like the tax part of it. Sometimes that drives people because they're like worried about the taxes, but I would say that's like not the most important piece of what we do.
No, I love it. Myth number 3, my spouse will automatically inherit everything.
Yeah, so like I mentioned, at least in New York, that's not the case. If you have young kids, even if your spouse is going to inherit everything, are they going to have to go through probate? And what if your spouse passes away as well and you're in an accident? Then what is the plan at that point?
Yep. No, it's I think I would have assumed. Like I feel like I can hear my dad's voice being like, I don't want to have to go through it all. Like, surely it'll just be fun, work it out. But that's not the case, Dad. So listen up. Myth number 4, estate planning is only for older people.
Yeah, so if only older people died, that would be a really...
Oh, that is... Yeah, I'm laughing because we've got to laugh about it because it's the truth, right? It's... Yeah, so basically there's no... like, that's okay. The counter to that is there ever... Is it just now is the best time? Like everyone should sort of have it in their mind and have at least had the chat.
Yeah, if you have any assets at all, if you're over here, even if you're over here and you don't have much assets, like who's your healthcare proxy? Who's going to make healthcare decisions for you if you were in an accident? Like that's something that is really important. So almost everybody has some issue that is important to plan for.
That's actually a really good point. I remember when I do have a will here in the US, and there's the will part, there's the health proxy part, and there's the living or the enduring power of attorney. I think they were the trifecta of... Is that... do you just want to quickly recap? That's actually probably a really good point, just to like summarize. What does a will, what does an enduring power of attorney, and what is a health proxy? What do they do?
So the will, 1, names guardians for your minor children, and 2, says who your assets go to. And they also appoint someone to manage that process. The healthcare proxy, or sometimes it's called an power of attorney for medical power of attorney or something like that, is for someone who is authorized to make medical decisions for you if you were not able to make those yourself. And a power of attorney authorizes someone to make legal and financial decisions for you.
Okay. So, and they, as part of the planning that you do, most people, if not all people, would get all three of those documents planned and structured as part of the planning process?
Yeah, that's kind of like a basic.
Yep. Okay. Myth number 5, the last one. This is too complicated to sort out from overseas. This one's an easy one.
It is.
Yeah.
Especially if you don't have any plan. So it's a really huge pain. So I would say, like, if it's too complicated now, you can only imagine how complicated it's going to be if you're not here.
Yep. Don't leave it to the people. People will survive you. So, and it's going to be a massive pain, and you could have done it in I guess, a relatively easy. Well, that's a good question. So if somebody sits down with you, and I'm going to link your 15 minutes because it's been absolutely fantastic. Thank you, Shannon. If somebody sits down with you, what does the process look like? How long does it, in general, take? If they they have the first little session with you, they fill in the forms, they come in, they sit down with you. Is it a sort of a day, and you've kind of done everything you need? Is that how does that actual process work? Yeah.
If it's just taking a day or with the wrong attorney.
That's a good point. Okay.
So we meet with our clients 5 times over the process. So They have an introductory meeting where we go over what the process is going to look like, schedule out all of their appointments so they know how long it's going to take. Usually, I would say it's going to take somewhere around 6 to 8 weeks. They'll have another meeting, go over who goes into what slots, or who are the people who are going to be taking on these roles and helping navigate those issues. You have a meeting we draft the documents, you have a meeting to go over all of the documents, make sure you understand everything. You have the meeting to sign the documents. Once they're signed, they're legally effective, but there are all of these other things, right, of like beneficiary designations being updated, things going into your trust, list of your assets. Does your guardian know what your kids need? Do they have allergies? Things like that you might not think of. We need to have all of those in place, so we have a meeting to go over all of that to kind of put the finishing touches on everything.
Okay. Shannon McNulty from the Village Law Firm. This has been absolutely wonderful. I know I mentioned a few times, if you're watching on Riverside, you can click this link for your free 15-minute consultation, and you are going to get an email that will detail this with the links and everything you need to know. I'm thinking Shannon will work on some little worksheets for people, because I think there's a couple of little notes that I think we can distribute in the next week or so that will get out and make sure that it's worth everyone's while. But I know I prepared notes and I've learned a lot. So thank you very much, Shannon, for everything you've gone through today. I know there's going to be a lot of questions that come up from this, and a lot of people that I think are going to feel a little bit better about knowing at least the bare bones, and as we've said, the general information that goes towards setting this up properly. So I sincerely appreciate your time. Thank you to everyone who are watching and listening. If you haven't already, check out our podcast, Moving to America. It's got a big photo of me on the cover with a nice pink background on the High Line in New York City. I would love to hear your feedback. We want to do lots of these. We want to do at least one a month and bring you something that really helps and informs and educates. So, Shannon, thank you very much again from the Village Law Firm. You've been wonderful tonight. Thank you.
Thank you, Josh.